Mr. Stewart, can I ask you, one of your 3 points was about viewpoint neutrality, and you say this is a viewpoint neutral regulation, and I think to some extent, at least facially, they agree. But there is this notion of the effect potentially having a viewpoint disparate impact, and I'm wondering whether and to what extent the government believes that there is any circumstance in which the impact could be taken into account when you're considering whether or not it's viewpoint neutral.
I mean, I wouldn't say that there's no circumstance in the law in which impact would be taken into account. I would say it would be anomalous to treat a consent requirement as viewpoint discriminatory based on speculation as to when people will consent. And copyright is another example. As with trademark, under the copyright laws, the owner of a copyright can consent to conduct that would otherwise be infringing. That's obviously a feature of patent law as well.
But is that just an argument about whether or not you believe the effect will actually occur? In other words, suppose we had data or something that indicated that they're correct, that the consent only occurs in one direction. Would that be relevant? Should we take that into account, or what?
I don't think it would carry the day at the end. I mean, we don't have the data, and I don't think there's really a reason to suppose that the withholding or giving of consent will depend on the nature of the message. One reason that either a trademark owner or a copyright owner might withhold consent is for fear that somebody else's speech will be misattributed to him. And the risk of misattribution is greater when you have a neutral or a flattering use of the mark. I mean, the one thing, presumably, if Donald Trump had been asked for his consent to registration here, the one thing he wouldn't have worried about is that if people saw this registered mark, they would think it reflected his own speech. And so we don't think there's a basis for believing there will be any systematic skew when people give consent. But above and beyond that, it would really kind of distort the application of both trademark and copyright law if we thought that a facially neutral requirement like consent can be treated as constitutionally suspect simply because the mark owners are more likely to consent in some circumstances than in others. And I'd point the courts to its decision last term in Jack Daniels as well. That is, the court decided some legal issues and it remanded for the lower courts to perform a likelihood of confusion analysis. And the court said Jack Daniels involved a parodic mark, a mark that parodied or mocked the original Jack Daniels mark. And the court said, in conducting the likelihood of confusion analysis, the court can take into account that commercial entities are unlikely to mock their own products, and therefore consumers will be less likely to think that a mark like this was actually produced by Jack Daniels than they might have been if the mark were more laudatory. And the court didn't suggest that because of that correlation between viewpoint and likelihood of confusion, the likelihood of confusion standard had been rendered viewpoint discriminatory or was constitutionally suspect. And that would really introduce, havoc is too strong a word, but something like havoc into trademark law, because likelihood of confusion is kind of the thing to be avoided in administering the trademark laws.